My current partner has 2 children. One of them children lives with us and one of them lives with Rex. Under the child maintenance scheme, they call that split care. One parent has full custody of one full custody of the other. The parenting time is still basically the same. So it's a parallel to the Regulation 50 where it is shared care. So she set up a case against my partner and he works. He was then told that he had to pay, it was about £500-600 a month to her. We had her of a child living with us. Because she's on benefits, the cap is £7 a week, Alexa. So £600 going to one child and then £29 coming back. Basically, when they've asked my partner to pay 12%, that's unaffordable because we have 3 other children in our household. That would basically financially impact them with the arrears that they have popped out of nowhere. So we believe there's false arrears on the account. They want to take 40% of his income per month. He then had to quit his job because he couldn't afford childcare for the 3 children that live with us, plus giving her £500-600 a month when he only got £7 a week from her. Even though they know 3 children are in his household, even though we've told them he can't pay because, and, he shouldn't have to pay anything, he shouldn't be liable for any payment to the CMS, they basically added £3,000 debt and couldn't explain it. And obviously they've added the 24% onto that calculation. That fee is not going to the children. That's being taken away from families, even in shared care and split care, right? I think the government make 106 million roughly per year from these charges, basically. They're looking to move every case to collect and pay. So that will generate them a lot more revenue in collect and pay fees. We said we can test the summons on these grounds, especially if there's other children involved. They said, if you contest the liability order that we want to put against you, basically, please don't turn up for court on the hearing date. So that is what they're telling people on these letters, that don't come to court. There were some people at court, as well as us, and he would not review the evidence. Also, the CMS didn't produce any evidence. So there was no evidence that they gave to the judge. The judge didn't review or see or hear any evidence that the CMS had. And all it was done is all 48 orders, even though people were there saying they don't actually owe anything. They don't owe any money, and they have all their documents to say that they paid their child maintenance, and they have none that they owe. And they were told, it states, you pay child maintenance if you can afford to do so. They should be doing assessments to ensure that people can afford child maintenance and they pay when they can do. And also that the children that are involved on the other side can have a good life and are supported by both parents. So this is not about not paying for maintenance. This is about basically all children and people being treated fairly. Is basically all your children should be treated equally financially, okay? By setting up in silo, like this in split care, that doesn't allow that to happen. So the CMS in the regulations have admitted that it doesn't exist. So basically they're not applying primary legislation. There has been a whistleblower who worked with the DWD who basically said, his calculations are going to basically put people into poverty, and they're going to basically put children into poverty. That was ignored. There was no proper consultation, research and modelling before the calculations were put in place. So they're applying the regulations and they're picking and choosing out of the primary legislation what they want to apply and what they don't want to apply. They basically sent us a document through the post, which said complaint and summons. But here's the issue with the document. The document didn't have any authorization information from the court. So there was no court numbers, there was no who authorized it, there was nothing. So I questioned this legally with the court. and I asked them to verify the order. There was no evidence of issue. So I then put in a freedom of information to the CMS. The CMS tried not to answer, but when they did, they kind of blurred it. But what they said in that is the CMS, and they said this, are issuing the summons, which breaches the Magistrates Act and it breaches the 1991 Act, child support. So in the 1991 Act, in section 33(4), the court has to issue the summons. They have to apply to the court, and the court has to issue the summons. They don't have to send it. The CMS can send it because there was a change there was an amendment to Magistrates Act. So in two primary legislations, it still has to be issued by a court. So by them issuing it themselves, the judicial step has not been, it doesn't exist, right? So what that does is it makes every liability order that the CMS are issuing void. The tribunals are very slim in regards to what you can challenge at tribunals. They can't look at arrears calculations and they can't look at the law and if it's basically lawful or anything like that. And that's set out in the 1991 Child Support Act, where actually the Secretary of State has discretion. So that brings up massive issues for Article 6, right to a fair trial. So we then applied for a judicial review. And judicial review was the only route where you could obviously challenge the, I suppose, legality and the compatibility of the regulations. So everything in that act and the safeguards within that act as well have to be adhered to in the regulations, but they've cut out the safeguards. There's a bit of both. There's like the human side of it and the tampering with accounts, especially closed accounts, but there's also the IT system, which has been known for years that it's defective. They continue to use a defective system. There's many recorded calls actually now by the CMS that say the system has caused these errors in calculation, but they still can't resolve the calculation. You know, they can't sort it out. And obviously then there's errors on errors on errors that the IT system's producing, and they just get worse and worse and worse. And then people have got like 30 grams debt, you know, that they don't owe or they've already paid. And there's a second issue is when people are changing calculations in the system. So we know that the CMS themselves go and change calculations. And we know that after a tribunal or when a decision's been made, the CMS aren't correcting them decisions, or if they're corrected, they're put back. They do the whole of the enforcement themselves. There's no one checking what they're doing, basically. So the whole process to prison is CMS. There's no Article 6. There's no way you can't go to a magistrate's court and challenge a CMS calculation, for instance. You can't challenge an arrears calculation. You know, the judge has no jurisdiction at tribunal. So there is no Article 6, and that is the biggest issue. They've carved it out.